Did you got this kind of payback for me? Is the first time 225. Another one you just go back for the rain.
I can't understand you. I'm sorry. What is the question again? Something about $200?
Say the first, this what they call roaches?
Roaches?
And
Okay.
first time is $225. I pay back. I have received.
Oh, did you pay her back? Is that the question?
Yeah.
Did he pay you?
Just to make
did
sure.
not pay me.
Yeah.
You did not pay me, sir.
Okay, I have received the gift.
Okay, well, ask her, show her the receipt. See if she recognizes that. Do you recognize that receipt?
No, ma'am.
Okay. Well, she doesn't recognize it. You can't give it to me. She doesn't know what it is.
Okay.
And it has not been admitted during your case.
This is Jeff. He keep asking me this stuff. I pay back to Jeff.
Okay, sir, you didn't admit that.
Okay, you are.
Mr. Pillow, how would you like to go sit outside? Mr. Pillow?
Second time $99 from rent.
Is that a question? Do you know if $99 was deducted from the rent?
No, because he had, again, his conversations were with Mr. Phillip. They were not with me.
All right.
You understand, the original money came from Mr. Phillip. The original, to look at the place came between him and Mr. Phillip.
So you really don't know anything else about this?
Actually, no.
Okay, sir, do you have any other questions? Because she said most of the conversations you had were with Mr. Pillow. She only knows what she testified to today, which is that she paid for the roaches twice, and she gave $700 for 3 months. And then she also testified about the way the apartment looked when she was in there.
And
The first time when she came with Mr. Pillow.
I did pay the light.
And the lights.
Being shut.
So you can ask her anything else, but she says she doesn't know anything else.
So every time I talk to this lady, first time we still he show up. Second time he show up.
What? You have to ask a question of the witness. Do you have another one?
So another say that for paying is a deposit. You remember? I'll give you receipts.
No, you did not give me a receipt, sir. You gave Mr. Phillip a receipt.
This
You
is
gave
your
Mr.
name,
Phillip
not for this guy.
You gave Mr. Phillip the receipt for the
Receipt.
apartment.
He's a party. He's a shepherd, but he's not the scientist. He's the only follow up. So for you pay this deposit.
I did not pay you. No, you did not give me a receipt.
Let me say something.
No.
You can't argue with her.
Okay.
But she's saying you didn't give it to her. You can't change her mind by arguing. You just have to accept her answer. You done? Ma'am, step down, please.
Thank you.
Do you have any more witnesses for the defense?
No, ma'am.
Okay. Mr. Pillow, last I checked, your name is not on this case at all. Mr. Pillow, we can't hold that against him. We can't. If that's true, there's nothing to do with this case. Okay, so the defense is now resting. I understand, ma'am. You have no more witnesses.
Yes.
Did you have any rebuttal testimony you want to give? Okay. I need you to raise your right hand again. You solemnly swear affirm testimony about to give me the truth, whole truth, and nothing but the truth.
unruly?
What?
Is it possible to start a unruly?
A new what?
Lease? Is it possible?
Lease? Okay, you know what? I can't throw my hands up here. I don't know what you're trying to do. You want to sign a new lease with him?
10 grand back for a new lease. You got these cheaper money like you're trying to do. That's
I don't know anything about 10 grand. No.
I gave you 7 in 2100.
Okay, excuse me. This is not a circus. This is a court proceeding. You just don't get to start yelling things that you want to say in the middle of the case. If you filed a counter complaint for some money, that would be one thing, but you didn't do that. So,
That she go to mediation next week for the money.
okay, well, I don't know what the mediation is for. Okay, you know what, Mr. Pillow? Get him out of here. Now. He got to go. Stay in the hall. It's too much. It's too much going on with him yelling at me. And he's not a part of this case other than a witness. So you may have another case. I don't know that. In this case, you do not have a counter complaint that I know of. And I'm going to check that right now. And you're free to do anything you would like to do with this man. If you want to sign another lease with him or whatever you want to do. But today we are here because he has filed a case against you for non-payment of rent. That's why we're here. In that case is for some damages for not cleaning and repairing. It should have been part of this case. She's claiming $2,700. Okay. So, sir, I just swore you in under oath. I have one question for you. Has this apartment been inspected by the city of Southfield for purposes of obtaining a certificate of occupancy to rent? Yes. Can you give me a copy of your certificate of occupancy? No, don't be lying to me now. If you got one, did you ever apply for one?
No,
Okay.
I don't know. There's only one here in Southfield.
You have to, there's a rental ordinance in Southfield. You have to go and register it as a rental property. Then they have to inspect it. Then they give you a certificate that you can rent. Did not do that. Okay. All right. Do you have any other thing you wish to say? No?
No, I just I want to take it back to the house. I don't want to pay something rent, lose some rent and stuff. Just I want to take it back to the horror deal.
Okay.
It's all right. Yeah.
What do you want to say? This is the closing argument at this point. So that summarizes what you would like the court to know and what you would like the court to do based upon the testimony that came out today.
If he would be open to it, I'd be open to, now that everything is, more or less clean, money returned for money that has been paid, would be to at least continue the lease until the end of.
Now, no, that's not what we're here for. You can, if that's what you want to do with him, you can do that afterwards. We're here for a closing argument on whether or not you owe him rent.
I have nothing.
You have nothing? Okay. Okay.
Runner. Again, I'm not trying to make this a circus or anything like that. Only thing I want to say is, again, this was actually supposed to be between gentleman and Mr. Pillow.
Okay, ma'am. Whatever was supposed to be. This is a nightmare as far as legalities are concerned. You should have never signed anything if it was supposed to be for Mr. Pillow. It's in your name, so you're the defendant, not Mr. Pillow. You're the defendant because you signed your name to a lease. And why you did that, I have no clue. Why you're even trying to negotiate some more lease, I'm not sure of that either. But your name is no question. The court is looking at, I heard all the testimony that I needed to hear. On March the 4th, I heard from Mr. Liu, somebody named Ms. Zhao. I heard from Mr. Pillow, and I've received all kinds of exhibits, and I've heard from you, Ms. Carlisle. One thing I do know is that this matter concerned a lease of property pursuant to Exhibit A, which is a residential lease, and Exhibit 1, both submitted by two different sides. One of them says Deborah Jean Carlisle. The other one says Deborah Jean Carlisle / Jeffrey Pillow. And if you ask me, they look like the same lease that somebody then wrote in Jeffrey Pillow's name on. I'm not really sure how that worked. The lease presented by the plaintiff has Ms. Carlisle only. The lease presented by the defense has both names on it. This case is only against Ms. Carlisle. It's for 16400 North Park Drive, apartment number 414, City of Southfield. The lease in both instances, it says from July 18, 2024 through July 31st of 2025. The rental rate is supposed to be $16,200 over the term of the, I guess, year.
Yes.
$13.50 in advance on the first of each month. Says there's a $35 late fee and must be paid by the 5th. And it says an additional $10 a day, which that is usurious. You cannot charge person a penalty. You can only charge them a late fee based upon the liquidated damages that it has caused you, like connected to whatever administrative costs or fees. This is a penalty. So $35 would be reasonable, but $10 additional day until they pay, that's a penalty, and you can't have a penalty clause. So we heard all this testimony over the course of the days about the fact that there was a contract, which I just said. Mr. Liu claims $700 was paid. The rent was $13.50, and that the defendant owed $650 plus $50 late fee for December, so $700, and then January, February, March. He probably wants now April, but at least through March, he claimed it was $4,900. I don't know who the witness number 2 was. She came and testified that the contract was signed on July 18th, that things were fixed before it was signed, and there was a problem paying rent. After they moved in, she said they didn't pay. She said there was some name not on the lease, but asked him, guess Mr. Pillow, to put his name on the lease because he was always calling. He called about bugs. He didn't want his name on the lease. The prior tenant didn't have any bugs. Now, she never said who she was and how she was connected to any of this, but this is her testimony. She said she requested photos, they never gave any. She said they called pest control, meaning the defendant and Mr. Pillow, without discussing it. And she said there was a $425 association fee which the defendant paid. Mr. Pillow testified there was a different version of the lease. He says a whole bunch of things, including that there was a security deposit. He paid $2,700, $1,350 2 weeks later. And then on August 1st, 2024, he paid August rent. He says when he got to the place and viewed it in July, that Mr. Liu told him to turn the lights on by their name on August the 1st because he had received a shutoff notice and the bill wasn't paid. He said he paid half of the rent in December because it was in somebody else's name, and he didn't pay half because it wasn't fixed up, it wasn't clean. We got the kitchen and bathroom photos, which pretty much show floors being dirty, grease on in the kitchen, and the toilet not clean in the first or second bath. He says he paid $225, which was testified to today that the witness, who was the defendant, actually paid that for pest control, and then another $100, and no one was reimbursed for that. He talked about, he being Mr. Pillow, talked about paragraph number 16 in lease, which says if the premises are wholly untenable through damage or destruction, not occasioned by the tenant, the lease is void. Well, there's no testimony about any damage or destruction, so I don't think that applies. If it's partially untenable, the landlord shall repair the same with deliberate speed. Well, there was nothing here talking about damage that had occurred. There was some testimony here from the, at least questions from the plaintiff about whether or not he told them that he wasn't going to be responsible for cleaning if they decided to pick up the apartment. Well, he can't do that because there are covenants involved, and there are statutory covenants for landlord-tenant cases, which make sure that landlords have places habitable. It's basically called a covenant of habitability. Owners of leased residential premises are obligated by statute to maintain premises in reasonable repair and compliance with health and safety laws of the state and local unit of government for the protection of any invitees or licensees of the premises. And the duty to pay rent by a tenant and the landlord's obligation to provide safe, habitable, fit premises in compliance with state and health safety codes are mutually dependent covenants. Breach of one of that latter excuses payment of some or all of the rent. And that's the law. So what we got here is a breach of covenants of habitability for sure. The place is filthy. It's not clean. You can't expect people to move into a place that's not clean. It's not necessarily in total disrepair, but it's not clean. And the plaintiff tried to waive the right to clean it. You can't do that. And, sir, I'm making a factual finding. I'm looking at the photos presented. You didn't present me any photos showing what the house looked like when supposedly she was going to move in, although they never moved in. Their testimony has been consistent. They never, at least this defendant didn't get a key. She never moved in, and the place is dirty. So that's a violation of the statutory covenants. And so that would absolve her for the right to pay rent. However, you are in violation of Southfield's leasing ordinance. You cannot lease a premises without having it registered and inspected. And the statute for the city specifically says if you don't do that, you cannot collect rent. So you don't have any claim at all against them for unpaid rent against her because you didn't register the property, and you're in violation of the covenant of habitability because you tried to give them property that wasn't fit for its intended use, which was to stay there. You can't give somebody a place that was dirty and say, I waive the right to clean it. You can't do that by law. And no one moved in, and quite frankly, no one should have moved in to a place that was filthy like this. So there's no counterclaim for any money that was due or paid already. You got another case for that. So I'm not ruling on that. I'm ruling right now, though, that the covenants were violated. He doesn't have a right for rent. That would be res judicata. That means if I rule that in this case, that would cover this whole lease, even in the other case. So you would have to bring that up to the magistrate, that this court made a ruling that the lease was, that the place violated the city's code, and therefore he has no right to collect any rent. And you can make that argument in your other case that that rent should be returned to you because that's what you're suing for in the other case. But this case is going to be dismissed for the reasons here stated on the record. Mr. Pillow still out there?
Yes.
He can come back now. We're done. But he better not be talking.
Judge, can I ask a question?
Yes, sir.
So how to, so then he didn't move in, he said he didn't move in, or take a apartment back. How can take the apartment back? So he said he didn't, he missing stuff he incident.
I know. And what's the question?
So, I want to take a apartment back, how,
Take your apartment back. Okay. You can't get it this way because you filed a complaint for non-payment of rent. And if they don't owe any rent, they get to keep the place. And they don't. So if you want to do something else, you can contact a lawyer, see if you have a claim to terminate their tenancy for some reason. And I don't know what it would be because you got a lease here and you're not supposed to have a lease.
so how,
Sir, you might want to talk to a lawyer because the court really can't give you a whole lot of legal advice. For everyone in here to fully understand, again, the court just ruled this was a non-payment of rent case. I ruled that no rent is due. So he cannot collect any rent and he cannot evict based upon rent being due. The reasons why no rent is due, number one, he's in violation of Southfield's rental process. It's called their rental registration ordinance, which requires a place to be registered and inspected by the city before rented. And the ordinance specifically says, no one, if they don't do that, you cannot collect any rent. So you're precluded from getting rent on that basis. Number two, I also ruled that this tenancy was in violation of the covenants of habitability because the plaintiff claimed that he wasn't supposed to clean it, that, that was on them. And that is a statutory right that cannot be waived, that he has to provide premises in a habitable state and maintain all of the repairs. And that just wasn't done in this instance. So on two bases, rent is just not due. So the court's entering a judgment after trial in this matter for the defendant there's no cause of action here. So he cannot retain rent, and the defendant would have a right to stay pursuant to the terms. And he may be able to evict on some other basis, but not this basis. And I also said that the ruling in this other case that the defendant has pending should have been a counter complaint in this case, but it's not. So I said that you need to let the magistrate, whoever's handling this case, at mediation as well as when you go before the magistrate, know that the court has already ruled that no rent is due because of violation of the rental ordinance and violation of the covenants of habitability. Therefore, if you're suing for rent that you pay, you need to let the magistrate know that so that she can give the appropriate judgment at that time. Do you have any questions? Do you have any questions? No. Okay. So I am getting ready to sign this. Anyway, you all don't need to stay. This is just going to come to you when it comes up.
You're gonna be mailing it?
Whatever they do once it gets into the system, they'll mail it out. Or if you have access to the online system, you can get it that way.
Thank you. Thank you.
Okay.
All set. Take care, Bill. Thanks, sir. Bill.
sign,
You don't have to sign anything.
so,
Sir, I can't talk about this because they're gone. So if you have any questions, you need to check with the lawyer once you get your judgment.
okay, thank you.
You're welcome.